Hello and welcome back. So today we will talk about the law on persons, personality, use of surname, and absence. So here we will look at civil code provisions. Why civil code provisions? Well, because these provisions were not amended or repealed by the family code. Now, while the bulk of persons and family relations is the family code, these provisions are still relevant, especially because they are foundation or introductory to the family code. And not only that, by understanding these provisions or these topics, we can also better understand the law on succession. So let's begin. So what are persons? Well, a person is any being or entity susceptible of rights and obligations or of being the subject of legal relations. Now, from this definition, clearly, inanimate objects or animals cannot be considered persons because they are not susceptible of rights and obligations or of being the subject of legal relations. Well, maybe to some extent they can be the subject of legal relations, like property, whereby two persons, the vendor and the vendee, may enter into a contract of sale over a real property or a personal property. But then, that is not the concept of persons. A person must be someone or an entity who is capable of performing obligations and of demanding rights. Okay, so now let's look at the types of persons. So there are two types. We have natural persons who are human beings. Cyborgs, robots cannot be considered natural persons because they are robots. They are not capable of birth or death. They may be created or they may be terminated, but we restrict or limit the idea or concept of natural persons to just human beings. Okay, artificial intelligence is not yet recognized. Of course, we don't know in the future, but at least for now, we limit natural persons to human beings who were born and could die. The other type of persons are the juridical persons, and these are entities formed by association of human beings. They are artificial and intangible entities which are considered persons only by recognition of law. So if it's not recognized by law, then it's not a juridical person. It may just be an association, it may just be a group or a club, but then if it does not comply with the requirements of the law to be considered an artificial or a juridical being, then it cannot be considered a juridical person. Hence, it cannot exercise rights, nor can it perform obligations. Okay, so keep that in mind. Now let's talk about capacity. There are two types of capacity: juridical capacity and capacity to act. Juridical capacity is the fitness to be the subject of legal relations. It is inherent in every natural person and is lost only through death. Now, this is a passive condition because it is the aptitude or the capacity of holding and enjoyment of rights. Capacity to act, on the other hand, is the power to do acts with legal effect. Note the power to do acts with legal effect. That's why it's an active condition or attribute, and this is the aptitude for the exercise of rights. Now, most people, if not all people, have the juridical capacity, but not all have the capacity to act. Because while juridical capacity is inherent in every natural person, regardless of age, place, okay, ethnicity, okay, but capacity to act, on the other hand, requires the possession of certain conditions or certain attributes, particularly age. Okay, so what is the age of legal capacity or capacity to act? Well, the answer is 18. And what is the basis? Article 1327 of the Civil Code provides that minors cannot give consent to a contract. And this is the reason why we say that capacity equates to majority because people below the age of majority are considered minors and thus cannot give consent. So what is the age of majority? Now that is provided, or that is answered to us by Article 234 of the Family Code as amended by Republic Act 6809, which provides that the age of majority is 18 years. Okay, so that's what I said earlier, that while juridical capacity is inherent in every natural person, capacity to act is an attribute that is acquired after meeting a certain condition, and this is the condition of age, meaning the person must reach the age of 18 years to have the capacity to act. Okay, now let's look at some situations or some acts under capacity to act and under juridical capacity. And here you will see that under capacity to act, it relates to some active attribute, something that can be performed or something that can be exercised. On the other hand, juridical capacity relates to that ability or that aptitude to enjoy something or to receive something. There is nothing to be done in juridical capacity, only to receive it or only to enjoy it. Capacity to act, on the other hand, is something that is proactive, something that is done consciously and deliberately. So examples of acts or powers under capacity to act are power to buy and own land, power to enter into contracts, power to dispose property, and power to buy pre-need plans. Okay, so there must be a conscious effort or deliberate effort to enter into the contract, to agree to the contract, and perform the obligations related to the contract. On the other hand, with juridical capacity, which is the capacity to be the subject or to be a recipient of a legal relation, we have the following. Again, these are just a few. This list is not exhaustive. So first is capacity to succeed to the estate. So even children can succeed to the estate. Okay, next, capacity to be designated as beneficiary in an insurance policy. Again, even a child, even a fetus can be the beneficiary of an insurance policy. Also, capacity to receive donations. The only requirement is that the donee must be able to accept it either in the same instrument or in another instrument. But it doesn't require agreement, okay, to the donation. So clearly, the donee needs only juridical capacity and not capacity to act. Last is capacity to be designated as beneficiary in an educational plan as a counterpart to the power to buy pre-need plans. So you have, let's say, parents or a single parent buying a pre-need plan. He can do so because he has the capacity to act. Juridical capacity is enjoyed by the child who is named as beneficiary in the educational plan. Okay. Now, do not confuse juridical capacity with a stipulation per autrui or a stipulation in favor of a third person. Now, of course, that third person may have both capacity to act and juridical capacity. Okay. But of course, when you say juridical capacity, it's not limited to a stipulation per autrui. A stipulation per autrui may also be an example of a situation showing juridical capacity because the person who is the subject of that stipulation, that third person who is the subject of that stipulation, also enjoys the rights pertaining to or arising from the legal relations of two other persons. Alright. Now, there are factors that can affect capacity, and let's look at these specific factors or circumstances as well as the effects of these circumstances. So first, we have minority, and the effect of minority is that the person is incapable of entering into contracts, and this incapacity is absolute. Okay, now as an exception in the law on sales, I think it's article 1490, okay, a minor who buys necessaries, okay, or the sale or the purchase of necessaries made by a minor shall be considered valid unless annulled. Okay, so necessaries fall under the concept of goods or services needed for the support and sustenance of a minor. So for example, a minor can buy food, a minor can buy school supplies. Now these purchases are valid until annulled, either by the minor himself or by the parent or guardian of the minor. And what are the grounds for annulling a contract entered into by a minor? Well, we have lesion or economic prejudice. And lesion or economic prejudice are two grounds for voidable contracts. Okay, so you have a situation, let's say, for example, a minor who buys food, but the food was too expensive, then that would not be considered necessaries, because the concept of necessaries is that it is reasonable and it should not result in economic prejudice or economic damage to the minor. Alright, so next is imbecility. So imbecility, of course, is a condition of the mind, and the effect is that the imbecile is incapable of entering into contracts, and this one is an absolute incapacity. Okay, now there is no exception to the absolute incapacity of an imbecility, okay, because of the feebleness of the mind of the person. Okay, now let's look at civil interdiction. Now we hear this often, both in civil law as well as in criminal law, because civil interdiction is an accessory penalty or an effect of a criminal penalty in some cases. So the incapacity here is relative, because the incapacity relates only to certain acts or certain contracts or transactions. Thus, a person who is suffering civil interdiction is incapable of exercising parental authority or guardianship. The person is also deprived of marital authority, as well as the right to manage or dispose property. But take note, a person who is suffering from civil interdiction may receive donations, may also receive inheritance, and all other passive transactions or passive acts. Okay? But as far as exercising parental authority over his children, exercising marital authority with respect to his spouse, and the right to manage or dispose property, that person cannot do these acts, because civil interdiction is a restriction on the capacity to act. Alright, now next, family relations. Now not all family relations are bad, but okay, the relations between husband and wife can prohibit or disqualify the husband and wife from selling or donating to one another. Okay, so the prohibition against sale of property with one another or to one another is found in your civil code under Article 1490 or 1491. Now, on the other hand, the prohibition against donating to one another is sourced from your family code. Now, the reason is obvious. This is to prevent prejudice to creditors, and also to prevent the exertion or exercise of undue influence by the wealthier spouse over the less financially capacitated spouse. Okay, so how about insolvency? Now, okay, by the way, as far as family relations are concerned, particularly the relation between husband and wife, this incapacity is relative. No? So I have to emphasize that it's relative, because the incapacity is lifted when they cease to be husband and wife. That's number one. And second, the relative incapacity does not apply when they have decided to follow a regime of separation of property, or they have filed and have successfully obtained a judicial decree of separation of property. Okay, so again, the reason for the prohibition is to protect the regime or the property relations that they have agreed or that the law has imposed. Okay, and also to protect third persons, as I've said. Okay, next is insolvency. And here, insolvency means the person's liabilities are higher or greater than his assets. Now, insolvency need not be, of course, established by the court or by a judicial decree. But in order to prevent a person or to incapacitate the person from entering into contracts, from managing his or her property, then an action for insolvency must be filed. And once there is a judicial decree, it's now an official declaration that he is suffering from this kind of incapacity. And particularly this incapacity is in relation to disposing property and receiving payments, because the court, the insolvency court, will have to decide or will have to approve, okay, what properties can be disposed, can be sold, or can be encumbered. And if payments are due, then the court will also order to which creditors these payments must go. Okay, because again, the creditors will have priority over the personal obligations that are due to the insolvent debtor. Alright, so it's a relative incapacity because it only relates to property and receiving payments, but it does not relate to personal obligations like rendering service. Okay, alright. Now let's look at absence. Absence is also a circumstance, but the effect is relative. The effect is that when a person is absent, then it gives ground for the appointment of a representative or an administrator of his properties. So an absent person may still receive, let's say, benefits, may receive inheritance, or may receive donation. But then, considering that he is absent, a person shall be appointed on his behalf to either sell or encumber his property, to make payments or to receive payments in case some obligations in money fall due. Okay. And these acts performed by the representative or by the administrator shall be binding upon the absent person and his estate or his properties. Okay, next is trusteeship. Now, trusteeship presupposes that a person is under the care of a trustee, just like a guardian. So the trustee exercises the power of administration of the property of the beneficiary or the trustor. Now, the incapacity here is only relative, or the restriction on the capacity to act of the beneficiary or trustor is only relative or limited, okay, to the specific property or to the specific transactions. Now, some reasons for trusteeship are, let's say, minority of the person or the beneficiary. Also, if the property is invested or placed for some purpose, let's say for deposit and all that. So if there is a reason or a legal obligation to put that property or funds under trusteeship, then the beneficiary or trustor cannot dispose of that property, okay, because the trustee has been precisely engaged to administer or to take care of that property or funds. But this incapacity is relative, and it ceases upon the termination of the trusteeship relationship. Okay, again, when will the trusteeship relationship terminate? It depends on the ground or the reason for the existence of the trusteeship in the first place. For example, minority. So once the person reaches the age of majority, then the trusteeship ceases. And so the person who has just reached the age of majority can now exercise full powers or full rights over his property. Also, with respect to trust funds or trust properties, if the trust relationship ceases, then the beneficiary or the trustor may now exercise full rights over the said funds or properties. Okay, so those are the circumstances that affect capacity to act. Okay, there's another one. I'm sorry. We have insanity. Now, this should also be read together with imbecility as well as minority. So, in insanity, the person does not have the mental capacity to understand or to comprehend the consequences of his contracts. His state of mind is, of course, prevents him from entering into contracts, from giving consent to the contract. That's why he is incapable of entering into contracts. But it is relative. Why? Because an insane person can have lucid intervals, and any contract or transaction entered into during the lucid interval is valid. Okay. Now, this is different from imbecility, because imbecility is absolute, because there is no lucid interval in imbecility. But in insanity, there is lucid interval. There is the possibility of a lucid interval. And we also have to consider or to remember that the law presumes a person to be sane. Okay? The presumption of the law is in favor of sanity and not insanity. But if the person has been declared insane, he is still capable of having lucid intervals. That's why an insane person may enter into contracts during his lucid interval. Alright, also there are additional circumstances, and we have here the state of being deaf-mute. Okay, you see, being deaf-mute simply means suffering from restrictions that involve the hearing and of course speaking, no? So that's why a person who is deaf and mute may be incapable of entering into contracts if by reason of his deafness and his muteness he cannot understand, communicate. He can understand, he cannot communicate. Okay. But if the deaf mute is capable of understanding the transaction or contracts, okay, because after all he still has his gift of vision or sense of vision, then the contract entered into by this deaf mute who still has full exercise of his vision can enter into contracts, and those contracts are still valid. Now, we will assume that the person who is deaf-mute has absence or has very restricted understanding of contracts. But this incapacity is relative because he can execute a will. Now, the will, after all, is a personal and unilateral act, so he can dictate it, assuming that he could be understood because he's mute. But if he could write it, then that last will and testament is valid and can be probated, of course following the requirements on the law on succession. Alright, now next is prodigality, and a prodigal person is one who spends more than necessary. Okay, so under the law, prodigality is a ground for putting a person under guardianship, and this guardianship is of course over his property and over his funds. It's not over his person, no? Guardianship of a prodigal person is not the same as guardianship of a minor. Okay, a guardian may exercise substitute parental authority over a minor, but a guardian does not have substitute parental authority over a prodigal person, but rather that guardian is only an administrator of the property of the prodigal person. Alright, now let's talk about commencement of personality. When does personality begin? So for natural persons, personality begins from conception. Okay, but provided that the fetus with an intrauterine life of at least 7 months is alive at the time it is completely delivered from the mother's womb. Okay, so if it is alive even just for 1 second, assuming of course the doctor can measure that 1 second, and of course there must be evidence that in fact it was alive even for 1 second, then that fetus is considered a person. On the other hand, if that fetus had an intrauterine life of less than 7 months, then that fetus must survive at least 24 hours after its complete delivery. It must have been alive for at least a day after his complete delivery. Now, what is the significance of these rules? Well, simply, that fetus, if he has acquired personality, may be the subject of juridical relations. Thus, it already has juridical capacity. So, an unborn child may be the subject or may be a beneficiary or may be an assured or an insured, sorry, the term is insured. That fetus may be an insured in an insurance policy. And so he must be born and must be considered a person under the contemplation of the law. And if that fetus had an intrauterine life of less than 7 months but did not survive 24 hours, then the contract is deemed cancelled. And thus the beneficiary, which in this case, in the insurance policy, could be the mother or the father, cannot, of course, avail of the proceeds of the insurance policy generally, because that insurance policy presupposes that the beneficiary or that the insured person must be a person. Okay, so the fetus or the unborn child at the time when the insurance policy was obtained must be born and considered a person for all intents and purposes. Okay, so following these rules. All right. Now, not only that, the Constitution states that the law shall protect the personality of a person or a child from the time of conception. Okay. Now, it doesn't require that the child must be born and be considered a person following these rules, but what it states that the state must provide measures, both legislative and administrative measures, for the protection of the child or the fetus in the mother's womb. Okay, that's why we have reproductive health laws on children, and all these are meant to protect the fetus so that it can be born well and it can become, of course, a alive and kicking person. All right. Now, for juridical persons, personality is acquired in accordance with the law creating or recognizing them. As we have said earlier, juridical persons are associations or intangible entities which are accorded the characteristic of a person provided that it meets the requirements or the requisites provided for by law. Okay, now private corporations and foundations begin to or become a juridical person, or the personality of these private corporations and foundations commences from the time of the issuance of the certificate of incorporation by the SEC or the Securities and Exchange Commission. It is not upon the filing of the articles of incorporation, but rather it is from the date of the certificate of incorporation issued by the Securities and Exchange Commission. With respect to partnerships, they are created upon execution of the contract unless otherwise provided by the agreement. Okay, so in the absence of a specific date for the commencement of the partnership, the meeting of the minds or the date when the partners agreed to form the partnership shall be the date when that partnership has commenced and shall have acquired juridical personality. Now, of course, when dealing with third persons, the third persons might require proof of the agreement. So, an articles of partnership may be presented. Okay, so it is from the execution of the articles of partnership that the partnership personality begins. Now, how about public corporations? As a rule, these public corporations, meaning local government units, government-owned controlled corporations, okay, they acquire personality upon effectivity of the law creating them. unless the law provides otherwise. For example, issuance of the implementing rules and regulations and the actual constitution of that public corporation. Note that under Section 14 of the Local Government Code, when a new local government unit is created, its corporate existence shall commence upon the election and qualification of its chief executive, meaning to say the mayor, okay, or the barangay chairman, okay, or the governor, okay, and a majority of the members of its sanggunian. Okay, so it is not upon the approval of the law creating it generally, but okay, it is from the time of the election and qualification of its chief executive and a majority of the members of its sanggunian. Unless, of course, the law also provides therein for a different time or a different situation, such as first making sure that the LGU or this new local government unit has already commenced performing its functions, or for example it has already met the requirements of, let's say, having an office or fixing its boundaries and all that. But as a general rule, a local government unit acquires personality upon the election and qualification of its chief executive as well as the majority of the members of its sanggunian. Now, death. Okay, of course, it's not the death, the tragic concept of death, no. But for legal purposes, death extinguishes civil personality. So if the right or obligation is not personal and is not extinguished by death, the heirs will succeed to the right or obligation. Because again, personality, and this applies of course to natural persons. Now, death extinguishes civil personality of natural persons. Okay, but take note that if the right or obligation can survive, then those rights and obligations can be assumed or enjoyed by the heirs of the deceased person. Now, the estate is also considered a person, but only after the death of the person to whom the estate belongs. So in the case of Limjoco versus Intestate Estate of Pedro Fragrante, the Supreme Court held that in this jurisdiction, an estate of a deceased person is considered as having legal personality independent of the heirs. And the estate commences, or the personality of the estate commences from the time of the death of the person, but it is terminated upon its distribution or partition among the heirs. That's why you have contracts or even cases entered into in the name of the estate of the deceased person, although the estate may be represented by one or more or all of the heirs, but that heirs or those heirs are only representatives, and the rights and obligations that are performed or are prosecuted belong to the estate and not to the heirs, at least not yet. Okay? Only after the estate has been distributed or partitioned among the heirs will that estate terminate or will that estate die. Okay, now under present legal system, such rights and obligations as survive after death have to be exercised and fulfilled only by the estate of the deceased. And if the same legal fiction were not indulged, there would be no juridical basis for the estate, represented by the executor or administrator, to exercise those rights and to fulfill those obligations of the deceased. Well, this is just something to further explain the idea that an estate has legal personality. Okay, now for juridical persons, we don't call it death, but rather dissolution. So in dissolution, a dissolution is any legal event or cause that terminates a legal entity. Private corporations are dissolved in accordance with the Corporation Code and Securities and Exchange Commission rules. Partnerships are also dissolved in accordance with the Civil Code. Now, dissolution may be voluntary or involuntary. I mean to say, those that do not violate the agreement are those that relate to expiration of term, accomplishment of purpose, and all that. But those that are involuntary, or that those that violate the agreement, would include death of a partner, withdrawal of a partner, and also dissolution by order or decree of the court. For example, when the object of the partnership is illegal, or when, let's say, the business for which the corporation was, or for which the partnership was created, has been declared illegal by either the court or by other government authority. Now let's talk about surnames. Now this one is, of course, very important and very relevant, especially for us Filipinos. You see, ours is a patriarchal society. By passing on the father's surname, we adopt the patriarchal heritage that people can trace their roots according to their father's name and their father's name. Now, married women, adopt the surname of their husband to assure that their children will be able to adopt the surname of the husband and clearly perpetuate that patriarchal heritage. Now, this is criticized by some as discrimination against women. But as I will show later on, women are not compelled, to adopt the surname of their husband. But at least with respect to the children, it is discriminatory against their mothers, because the family name or the surname of the mothers will ultimately be lost, because what is brought or perpetuated through generations would only be the surname of the father. But then that's just the way it is. So dura lex sed lex. Alright, now let's talk about rules on surnames of children. So legitimate and legitimated children shall use the surname of their father, and this is provided under Article 364 of the Civil Code and also by the Family Code. Because we have a patriarchal society and we follow the patriarchal heritage, thus legitimate and legitimated children, or children that are conceived or born during a valid marriage, will of course follow the surname of their father. Now, included here are children who were conceived or born before a decree annulling or voiding a marriage. So even though the marriage will ultimately be terminated due to Article 36 of the Family Code on psychological incapacity, or Article 45 on annulment of marriage, or let's say when the marriage is annulled because of the marriage of an absent spouse, of the present spouse, and the absent spouse reappears, and of course the subsequent marriage is declared null and void. The children born out of those relationships, or out of those marriages, are considered legitimate children, and thus these children will adopt the surname of their father. Now, with respect to adopted children shall bear the surname of the adopter. But take note that if the adopter is married, then both spouses should adopt the child. If the petitioner is the mother, meaning to say is the wife, and since the husband is a co-petitioner or co-adopter, the adopted child shall follow or adopt not the surname of the main adopter, which is the mother, but rather the surname of the husband, who will ultimately become the adoptive father. So take note of that. The rule that the family name of the mother, the adoptive mother, will be followed or adopted by the child applies only if that adoptive mother is single, or is formerly married, but her marriage has been annulled or has been rendered void. But if the child was adopted by a woman who is married and both of them are joint petitioners, then after due proceedings and that child is adopted, that adopted child shall adopt the surname of the adoptive father. Okay, now let's talk about illegitimate children. And under Article 368 of the Civil Code and under Article 176 of the Family Code, illegitimate children shall bear the surname of the mother. But note that in 2004, Congress passed Republic Act 9255, which provides that illegitimate children may use the surname of their father if their filiation has been expressly recognized by the father through the record of birth appearing in the civil register, when an admission is made in a public document, or when an admission is made in private handwritten instrument. Okay, now the proof of filiation through a record of birth is the signature of the father in that record of birth or birth of or birth certificate. Now, on the other hand, an admission made in a public document is an affidavit of admission of filiation. Okay, so it's an affidavit because it's a public document. Now, on the other hand, or the third evidence is a private handwritten instrument. So it can be a diary, it can be a letter, okay, that is privately made and not subscribed or notarized. Now, in addition, an affidavit to use the surname of the father may be executed by the child, his or her mother, or his or her guardian. But this affidavit to use the surname of the father, or AUSF, may only be filed if the father has already admitted the filiation, either through the record of birth, through an affidavit of admission of filiation, or through a private handwritten instrument. The affidavit to use the surname of the father is not the proof of filiation, but rather it is just an affidavit filed with the local civil registry office in order to avail of the benefit of Republic Act 9255. Okay, it's not a separate proof of filiation. Okay, because that affidavit to use the surname of the father is sort of like an application, okay, to use the surname of the father. Now, by way of exception, okay, since this is also a public document, that affidavit to use the surname of the father may be deemed an affidavit of admission of filiation if that affidavit to use the surname of the father, or AUSF, was signed, executed, and submitted by the putative father. And that's the exception. Alright, but as a rule, an affidavit to use the surname of the father is not the proof of filiation. It is either the record of birth, it is either the affidavit of admission, or a private handwritten instrument. And the AUSF simply is the covering letter, so to speak, or even if filed separately, it is deemed the application to use the surname of the father. Now, where and what to file? If birth was in the Philippines, file, okay, any of the following: affidavit of admission of paternity, private handwritten instrument, or affidavit to use the surname of the father at the local civil registry office of the place of birth of the child, and not in the LCRO of the place of residence of the father, or residence of the child, or residence of the mother or guardian, but rather it is to be filed at the LCRO of the place of birth, because that LCRO has the exclusive power or jurisdiction to change, okay, the record of birth of that child, or at least to annotate, okay, the change of surname on that local civil, on that certificate of birth. So it cannot be filed anywhere else. Neither can it be filed with the PSA, or the Philippine Statistics Authority. Okay, now if birth was outside the Philippines, file any of the following. Now this is different from the previous rule because here the birth was outside the Philippines, and the parties involved may be in different places or in different countries. So the IRR, or the Implementing Rules and Regulations of Republic Act 9255, provides the following procedure. So first, file any of the following: affidavit of admission of paternity, private handwritten instrument, or affidavit to use the surname of father, at the nearest Philippine Foreign Service post, meaning embassy, mission, or consular offices nearest to the place of residence of the person concerned. So, for example, if it's affidavit of admission of paternity, then the nearest PFSP or the PFSP nearest to the place of residence of the father, because after all, it's the father who should execute the affidavit of admission of paternity. For the private handwritten instrument, then also the file it with the PFSP nearest to the residence of the father who executed the private handwritten instrument. Now, for the affidavit to use the surname of the father, the proper PFSP is the PFSP nearest to the place of residence of the person filing the affidavit to use the surname of father. So it could be the father himself, the child, or his mother or guardian. Now, let's look at notable cases, and these cases interpret or make Republic Act 9255 and the benefits found therein clearer. Okay, so let's look at Grande versus Antonio. So here, the father filed a petition for judicial approval of recognition and to change the surname of his illegitimate children to that of his surname. Okay, because obviously the local civil registry office did not change the name of the illegitimate children, okay, despite proof that he was the father of these illegitimate children. If you have read this case, these children were brought by the mother abroad, okay, because the mother and Mr. Antonio parted ways. They did not end up, together forever, but rather they parted ways, and they did not even get married. Okay, so the father now filed a petition to compel the recognition of the children and to compel the change or correction of the birth certificates of these children so that his surname could be used by these children. So here the Supreme Court held that Article 176 of the Family Code, as amended by Republic Act 9255, gives the illegitimate children the right to decide if they want to use the surname of their father or not. It is not the father or the mother who is granted by law the right to dictate the surname of their illegitimate children. That's why, if you will remember, RA 9255 provides that illegitimate children may use the surname of their father. The operative word there is may, and it's not shall. Okay, so clearly, no one can dictate upon the illegitimate children to use the surname of the father. Okay, it is entirely the illegitimate children who has the right, okay, to apply and to make use of the surname of the father. Also, the IRR of Republic Act 9255 was declared void insofar as it provides the mandatory use by illegitimate children of their father's surname upon the latter's recognition of his paternity. So in the old IRR of Republic Act 9255, the word used was shall, and also the local civil registry office was instructed to make the necessary correction once the father has filed, of course, has filed the affidavit of paternity or the private handwritten instrument or the AUSF. But then here the Supreme Court said that it's not for this father or the LCRO to motu proprio change the names of the illegitimate children. Now, if the illegitimate children are still, of course, minor, then the mother can decide for the illegitimate children. Okay, so let's say the illegitimate child is, say, still 1 year old, 2 year old, or at any age before the age of majority, then the mother, okay, may exercise that. Okay, of course, in the best interest of the child, it must be considered or deliberated if in fact the use of that surname will be for the better welfare of the child. Otherwise, of course, if the use of the surname will not benefit, or it will not be obvious if the use of surname will benefit the child, then it is only the child, upon of course reaching the certain the age of, let's say, consent, that legitimate child has the sole right to decide whether he wants to use the surname of the father. Okay, now another case is De La Cruz versus Gracia. Here, the mother of the illegitimate child filed an affidavit to use the surname of the father, attaching thereto a document entitled Autobiography of the Father. It was a handwritten document, but then it was not signed by the father. So the question is a private handwritten document without the signature of the father admissible as proof of filiation or paternity under Republic Act 9255 for the purpose of allowing the illegitimate child the use of the surname of the father? So here the Supreme Court said that Republic Act 9255 is not a law in isolation. Okay, it must be read together with Article 175 of the Family Code on how to establish filiation. So here the Supreme Court ruled that the autobiography, although a private handwritten instrument included as among proofs of filiation under Republic Act 9255, must be signed by the father as provided under Article 175 of the Family Code on how to establish filiation of legitimate and illegitimate children. Now, the case, however, must be read because here the mother of the illegitimate child presented additional evidence, not just the autobiography of the father, particularly the admission of the grandfather of the child, meaning the father of the putative father. So here, according to the Supreme Court, due to the presence of other evidence, the filiation was established. Hence, the child was allowed to use the surname of the father. Okay? Alright, now let's look at rules on surname of married women. So a married woman may use her maiden first name and surname and add her husband's surname. Okay, so that's the first rule. For example, Maria Cruz Reyes, Reyes being her husband's surname. Next is a married woman may use her maiden first name and her husband's surname and dropping her maiden surname. So in the same example, she can just use Maria Reyes, thus dropping the name Cruz. Okay. Also, or the third way is for that married woman to use her husband's full name but prefixing a word indicating that she is his wife, such as Mrs. Okay, but not mistress. Alright, so for example, Mrs. Pedro Reyes, Pedro being her husband's first name. Okay, so she's the legal wife because she is the Mrs. Pedro Reyes. But take note, I emphasized here the word may because it is again discretionary on the part of a married woman to use the surname of the husband. That's why a married woman may just continue using her maiden first name and maiden surname. Because if she wanted to adopt the surname of her husband, either by any of these, meaning to say she could adopt the surname of the husband by attaching it or appending it to her present name, or to drop her maiden surname and adopt the family name or surname of her husband, or just totally drop her first name and surname and adopt the name of the husband and then prefixing it with Mrs. All these changes must be recorded with either the government, with the government offices, with private offices, and all those offices with which she has dealt or she has been dealing. Okay, now that may be, of course, hassle on the part of the married woman, but then the reason for these rules on surname of married woman is rooted on our culture. It's not so much of an invention of the law, but rather the law validated or confirmed the usual practice of married women in this jurisdiction when they marry and adopt the use of or adopt the surname of their husband. So these are the three ways by which a married woman may, should she decide, okay, to use the surname of her husband. Alright, now, when may a married woman revert to her maiden name? Well, there are two instances. In case of annulment of marriage and the wife is a guilty party, so it's mandatory. The married woman must revert to her maiden name because she was the guilty party. Okay. Now, what is guilty party? Of course, it is the party who concealed a certain fact that gave ground to the annulment of the marriage. Now, if the married woman is the innocent spouse, meaning to say she was the offended party, the change of or the reversion to her maiden name is optional. In other words, the married woman may still keep the name of her husband, for after all, she was not the guilty party, so the law will not impose that as a penalty. Okay, but she has to revert to her maiden name, okay, if the court so orders. Okay, so for example, in that annulment case, although the married woman is the petitioner because she is the offended spouse, the court in the decision may still order that she be reverted to her maiden name in order to avoid any trace of a bad relationship or a bad marriage. Now, the other reason or instance when the married woman, although innocent in the annulment case, should revert to her maiden name is when either she or her husband has remarried, because it would be absurd if she would still keep her formerly married name when her husband has already remarried. Okay, so that husband should only have one wife, and one wife who has the right to bear his surname. Okay, note that in legal separation, there is no change. Okay, even though there is a decree of legal separation, there is no change. Why do you think that is? It's because the marriage bond is not severed in legal separation. Legal separation is just a separation in bed and board. Okay, they are just separated physically, okay, but they are still married under the eyes of the law. So there is no change. Okay. Now, let's talk about absence. And this is the last topic. So, absence, when a person disappears from his domicile and his whereabouts are unknown. Okay, so that is the definition of absence. Now, absence shall be declared, okay, after a period of 2 years or 5 years in case the absentee has left an administrator of his property. Okay, so if there is no administrator, then the absence of 2 years is enough. Okay, now what is the effect of absence? The administrator of the absentee's properties shall be admitted or shall be appointed. Now, if the present wife is appointed administratrix, she cannot alienate or encumber the husband's property without judicial authority. Okay, however, note that no similar rule is provided in case the present husband is the administrator. So it appears that in case it was the wife who was absent, the present husband as the administrator may sell or encumber, okay, the wife's property without need of judicial authority. Well, remember that the civil code is a very patriarchal law. Okay? Much preference or much discretion is given to the husband, both in parental authority and even in the administration of the conjugal or the community property, and more so in case of the wife's property if the wife is absent. All right, now let's talk about absence as presumption of death or as evidence of presumptive death. So for all purposes, an absence of 7 years shall be considered presumptive death, meaning to say a person who has been absent for 7 years shall be presumed dead. Okay, now for purposes of opening succession, we have different years or different periods. So ordinary is 10 years, meaning to say a person who has been absent, who has left his domicile and whose whereabouts are unknown, shall be considered dead for purposes of opening his succession and allowing his heirs to divide and to partition the property after 10 years. Now, of course, there is a need for a judicial declaration of presumptive death. Okay, so the interested parties, meaning to say the heirs, must file a petition to declare the decedent presumptively dead after a period of 10 years. But if the person became or if the person was absent at the age of 75 years, or if the absentee was 75 years old at the time, then a period of 5 years would be sufficient to declare him presumptively dead. But if the absence is due to extraordinary reasons or grounds where there is danger of death, then a period of 4 years would be enough. Now, next is for purposes of remarriage, and that is provided under Article 41 of the Family Code. A different period is also provided. So ordinarily, it's 4 years. So if the person was, or if the absent spouse left the domicile and his whereabouts are unknown for at least 4 years, then the present spouse may file an action in court to declare the absent spouse presumptively dead. And after a final decree, then the present spouse may now remarry. But in extraordinary absence, where there is danger of death, a period of 2 years is enough. So what is this, or what are these extraordinary circumstances where there is danger of death? So these extraordinary circumstances are as follows. So a person on board a vessel lost during a sea voyage, or an airplane which is missing. Also a person in the armed forces who has taken part in war, and a person who has been in danger of death under other circumstances, but almost similar to the first two circumstances. So for purposes of opening succession, 4 years. In case of extraordinary absence where there is danger of death, 4 years for opening succession. But for purposes of remarriage, it's just 2 years. Okay, absence of 2 years under extraordinary circumstances where there is danger of death. Okay, 2 years would be enough for the present spouse to remarry. Okay, so that is absence for you. And so I thank you. Thank you very much for watching this video, and I hope you learned something today. Now I am uploading this on YouTube, and in fact I have already uploaded this. So if you enjoyed this video, please drop a like, and if you want to see more videos, to watch more videos, please subscribe and click that notification bell so that you will be notified in case I upload a new one. And with that, I leave to you my statement that laging tatandaan, isip ay buksan, alamin ang batas. Thank you.